another level of protection a little bit higher. WIPO recommendation now. Well, we have first the definition of a well-known trademark. Well, I will not use definition as a word because for me, in my opinion, we still don't have any way to define a well-known trademark. I mean, you will never be able to say, okay, if you fulfill all these requirements, you will have a well-known trademark. You will never be able to say, okay, this trademark is well-known and it's well-known. So quickly, criteria, so degree of recognition, the use, the promotion, registration, successful enforcement, value, type of channel, and business circles. So all these are criteria that should be taken into consideration when assessing a well. Then there are also some articles about code protection, the role of bad faith. And then important part is the Article 4 that explains the different conflicts. So if you see, if you look, you have Article 4.1 covering identical similar products. So basically same protection as Paris Convention and 16.2. And then you have the second protection products. But here, introduced a test, while was only about one. The first, the use of that mark would indicate a damage. Second test is also available according to WIPO. So the use of that to impair or dilute in a manner the distinctive character of the mark. So here we have the dilution that is another system that is more available in the US and in India to some extent. And then the use of that advantage of the distinctive character of the well-known mark. Well, this is what we have in most of the countries. So I was talking about the 3 level of protection. Well, quickly, 3 level. First level, Paris Convention. First article of first part, so 16.2 of TRIPS and 4.1 of WIPO recommendation. Protection for unregistered well-known mark for similar products. So conditions, identical similar marks, similar products, and the test is the likelihood of confusion test. So simple test, like a normal conflict between 2 trademarks. Then you have the second level, that is a registered well-known marks regardless of the products and services. So in that case, you have different conditions, so identical similar marks, different products, and different tests. So as mentioned previously, we have the likelihood of taking unfair advantage of the repute of the mark. This is what we see in EU, in Europe, and in India. Likelihood of connection, that is also something we see in Europe and in India. Then we have likelihood of being detrimental to the repute of the mark, Europe, India, USA. And finally, likelihood to cause dilution. Using the word dilution is really US and India. And then there is also a third level of protection that is not required by international rules and legislation. This is, well, giving the protection for different products and services when the trademark is unregistered and well-known. So what is the principle? Well, the principle is level 2 in Europe, USA, and India. Now, there are some exceptions. For example, in Europe, well, the EU legislation is granting level 2, but still some national legislation are granting level 3. This is, for example, Denmark, Slovakia, and Latvia. They are recognizing the protection for unregistered well-known trademark for different products and services. Then in India, the situation is a little different because we have a mix of the different tests that we saw in level 2. So we have the dilution test, we have the connection, we have the detrimental. So we see cases with all these tests, and they are just using all the different tests together. Also in India, so a little, sometimes the protection is a little lower because the similarity of the products is still sometimes taken into consideration. And there is also a big room for the honest concurrent use defense. And so it lessens a lot the protection of well-known trademark. Finally, in the United States, well, even if we always think that the protection is really great, well, before 2009, dilution was only for identical or nearly identical marks. So it means that it was not even level 2, because you only had protection for well-known marks if, for different products, only if you had identical or nearly identical. And then since 2009, some decisions are recognizing a broader scope. So one in the 9th Circuit, and then one in 2nd Circuit, and finally one in TTAB. But so it means that in all the other circuits, we are still with a system where only identical or nearly identical trademarks are protected. So what can we say? Well, it's progressing, and level 2 should be a minimum that should be reached everywhere. So here, after that, I was asking myself, well, why are we having so many problems considering well-known trademark when we see that the system is quite good and the system is nearly reached everywhere? And so I think the issue comes from the fact that the decision and the assessment of the well-known character of the mark is not binding. So let's take an example in Europe. So I guess, because it's a well-known mark, you all know Boss, so the trademark Boss. So if you take the trademark Boss in Europe, just the word Boss, word mark Boss, you will see that in 81% of cases, reputation was recognized, and in 19% of the cases, the reputation was not recognized. And so this is the first thing that we can notice. But then we can also notice, well, that some countries are consistent. So for example, Italy is always saying, okay, reputation. But then if you look European instances, you have 5 decisions and you have 50-50. So 5 decisions, 50-50, mean that there is even one decision where they are saying it's both reputation, no reputation. So this is kind of a problem. So why do we have this kind of result? Basically because the system, even if we are using everywhere the same factors, the one from WIPO recommendation, we are still doing a case-by-case analysis. So we are looking at the facts of the case to see if yes or no the trademark is well known. And also, why? Because you will see in a lot of decisions a little sentence that for me makes, well, not a lot of sense, is the trademark is well known in relation to some products or services. For me, it's just contrary to the principle of well-known trademark. And so I will show you why, well, it leads to that. So, not binding, no consistent protection. This is a result of we have no list. So an example of solution was given in India, where in Article 11, Paragraph 8 of the Trademark Act, basically it said that where a trademark has been determined to be well known in at least one relevant section of the public in India by any court or registrar, the registrar shall consider that trademark as well-known trademark for registration under this act. So it means that at least for registration matters for the registrar, the decision from court and registrar are binding. So at least you have some consistency over there. Now, what I thought about is why don't we have just a list? So a list, of course, it's not perfect. It's not perfect because, well, you have to assess so many factors. But at least for the big trademarks and the trademarks that are well known, we should have a list. Why? Need to guarantee a consistent protection for the trademark owners. Because if you have a trademark and you see you have 10 cases with your trademark, and in 10 cases you are good and considered as well-known trademark. Imagine you are just sure that you will win and that you will be able to apply the test apply the test on different products and applies infringement on different products. Well, you go and then this judge, because for one or another reason, decide that, well, your trademark is not well known, because it will not assess in the same way the different factors. Then we also need to inform the later applicants. So imagine you are going, you check the list, and you see that the mark is in the list. Well, you know it's really dangerous to go and to file your application or to try to infringe that mark. Now, if you see that it's not in the list, well, normally it should be easier if you are not on same products. And last thing, as I mentioned before, well known in relation to certain products and services, well, for me, doesn't make a lot of sense. If you want to protect a trademark, even if the products are not the same, how can you then say that a trademark is well known in relation to certain products and services? So we need, for me, to have a list, but by area. I'm not saying a global list, even if one day I guess it will come, but at least we should have a local by area list. And so you might say, well, it will be really complicated, really impossible, and how can we do that? Well, it's quite easy. Just checking on the system, just taking OHIM, I found 1,202 cases where the trademark was considered as well-known. So this is at least a beginning, just for OHIM, of 1,202 trademarks. Thank you for your attention.